Thank you for joining us today to discuss antitrust in the Americas, recent trends and debates. This panel was proposed by Miguel Del Pino, and we have here...
And Rivas.
And Rivas. So I'm Ana Bachaglenk from Machado Meyer. I'll be moderating the panel, and I have here brilliant speakers from all over America, from Argentina, Chile, Colombia, Mexico, and the US to help me and help us navigate this very interesting topic. So I'll start with Miguel Del Pino, partner at Marval in Argentina. He has great experience in antitrust and competition issues and also broad teaching experience. At my right, Amilcar Peredo, head of the antitrust practice at Basham, Ringe, and Correa in Mexico. He published one of the first textbooks in Mexican antitrust law in Mexico. Then I have here at my right Beatriz Hidalgo, director at Ferrada Neme in Chile. She has degrees in legal, social services, a diploma in economics, and also an LLM from the King's College. And she's also a teaching assistant at the University of Chile. We also have here Felipe Serrano, partner at Serrano Martinez. Before being a founding partner of his firm, he was chief advisor and deputy head at Colombia's Antitrust and Privacy Agency, SIC, and he's the president of Colombian Antitrust Association. And we also have here Christian Catona, vice president of Global Competition and Regulatory Policy at CCIA. Before this role, he served for 15 years at the FTC, among other roles as counsel for international antitrust and as an attorney in the agency's technology and enforcement division. So, well, good morning, everyone. Thank you very much for making all the way to São Paulo so that we can have this interesting discussion. First, our rules on the panel. We will discuss 4 topics: merger control, cartels, abuse of dominance, and digital markets. And any speaker can skip a question if they want to spend more time in other topics. And we would also like to make this panel open for questions. So if you have any question that is relevant to the topic that is being discussed, please feel free to jump in and make the question. The speakers agree that they can be interrupted if the question is pertinent. Otherwise, please save it to the end. So let's start with merger control. I'll start with Miguel. Miguel, what's going on in Argentina right now?
Thank you, Ana. Let me see if is this okay? Hello, everybody. Thank you for the invitation. Ana, it's a pleasure being here in Sao Paulo. It's a pleasure being with all my friends for IBRAC. I think I started coming to this conference in 2003 in Brasilia. So it has been a long time participating at the IBRAC's events, which are amazing, incredible. I'm always surprised about the amount of people that participates at this conference. It's really exceptional. So congratulations for that, and thank you very much for the invitation. Going to merger control in Argentina, the first question that we all have about Argentina and merger control is when the system will change, because it has to change. It was provided in a law in 2019. It was supposed to change, but it has not yet occurred. Hopefully, it will occur sooner. First, let me tell you, what the law states is that the system will shift from post-closing analysis to pre-closing analysis a year after the new authority is set up. And the problem that we have is that the new authority has never been set up. We still have the Antitrust Commission that was set up at the beginning of the 80s, and we have had several laws and the same authority, which is really the Antitrust Commission and the Secretary of Domestic Trade. The Commission has no powers to decide. It only issues recommendations, and decisions are taken by the Secretary of Domestic Trade. The system is supposed to shift once this authority is created. What we are hearing, this past government has had intentions of creating the tribunal, and even they drafted a decree. They wanted to create the tribunal by decree straight, instead of following what the law says, which is basically appoint independent members of the tribunal by a special contest. But this past government, and past because supposedly it's going to change very soon, wanted to create a tribunal. They drafted a decree, we reviewed that decree, we commented, and that decree was never executed by President Fernandez. We have elections next week. It's second round elections. There are two candidates. The economic situation in Argentina, as you all know, is not the best one. And both candidates have mentioned that they will try to, I would say, amend the system to try to create economic certainty and try to promote foreign investments. And both candidates have intention of regularize this issue with the antitrust law, meaning the creation of the law and the shifting of the system from post to pre. And I want to skip because I know that I don't have that much time, so I won't talk about threshold and all that stuff that is very boring, and it's in all the newsletters that you can see all over. Let me tell you that a new system for the filing of the economic concentrations was passed at the beginning of August, was passed in June and started to be effective at the beginning of June. We have a new form, we have a fast-track system, so transactions that have no overlapping or only a few overlapping have a shorter form, and the authority has 20 days to decide whether they will approve the transaction or they will require the old Form F1, which is a very, I would say, burdensome form similar to what they do in the EU. So that's something new in Argentina. And the other thing that is new is that with this regulation, and talking about efficiencies when they have to approve transactions, the Antitrust Commission is requiring now proof of ESG benefits. So if you have a transaction with let's say, with an important and overlapping, but you can effectively prove ESG matters within the efficiencies, they will try to approve the transaction. And what I mean with ESG, because in reality is that we are basically saying that it's ESG, but they are thinking about substitution of imports, creation of employment, sustainability issues, protection of environment, gender equality policies. So the Antitrust Commission has started to take into account those matters when they are analyzing a transaction. And let me finalize with an example, because we do have a transaction right now that is very problematic. The Antitrust Commission is thinking in imposing remedies. We are negotiating the remedies, and I prove tons of ESG matters, and the Antitrust Commission told me this is good, but we still have the competition issue. So what I meant by this is that they are reviewing the ESG matters, but still competition matters is their area of concern. And with that, I will leave it for the moment.
Very interesting, Miguel. Thank you for sharing. Amilcar, what about in Mexico?
Thank you, Anna. Hi, everybody. Good morning. Thank you. I join Miguel in thanking for the invitation. It's a pleasure to be here with all of you. My first IBRA conference was together with Miguel, but I think it was 2006 or 2007. Many of you were at elementary school at that time. Hopefully, Miguel, the fast track in Argentina will work better than in Mexico. The issue that happens in Mexico with fast track is that you spend more time trying to argue that it qualifies for fast track rather than if you go for the ordinary filing. Another issue is that if you go for the fast track, it needs to be very robust, because if you receive an error file, it could be an error file for one or two things, you will be out of the fast track procedure. So our recommendation in Mexico for all clients, whenever they believe that transaction qualifies for being analyzed under the fast track procedure, is not to do it. It's better to go for the ordinary filing, but hopefully in Argentina will work. What about mergers in Mexico? Well, just for statistics, in 2021 there were 165 filings. Last year, 2022, 168. And this year, last week we filed number 109. So it will be, and we are already in November, so it will be well below, what has happened the last couple of years. And I can say that generally the average, it's 160, 170. So this year it has substantially slowed down. Going into substance, historically, the main concern of the Competition Commission, COFECE for its acronym in Spanish, the main concern for many years has been the creation of a dominant company as a consequence of that transaction. That has been the story for many years, until the last, I will say, maybe 2 or 3 years, in which the Competition Commission has put more attention in, well, not more attention, they have now realize that the theory of harm may arise not only by the creation of a dominant player, but also by the market conditions after the transaction, namely coordinated effects. Early this year, we get approval of a transaction. It was a very complicated case. It was a market of 4 players, and the number 2 and number 3 were filed for merging among themselves. But as a result of the transaction, the leader of the market will still be the same, and it was the clear dominant, the clear leader of the market. But COFECE didn't care about that. Since day 2 of the filing, they raised the big concern that the market will change from 4 players to 3 players, and that will facilitate, well, disincentivize the competition among the 3 remaining main players, and could facilitate conditions for colluding among themselves. It took like 9 months to get clearance for that. We need to hire a very reputable economist firm. They did a very good job, a very technical analysis showing that it won't harm the market, the transaction. So it got cleared. So that's why, and it also happened in another market, in the movie theater market. There were 3 players, and they rejected a merger between 2 of them. Then they appealed, then it was approved subject to certain conditions. So my point here is that nowadays COFECE reviews also the potential coordinated effects that might result from the transaction. The other issue that we have seen lately, and in the past it was not an issue, it's vertical effects. In the past, for many years, if they see a vertical relationship among the merging parties, they just ask a couple of questions about that, and that was it. But nowadays, whenever they see this vertical relationship, they ask a lot of questions about that. They raise concerns about that relationship and the effects that the vertical relationship could have. I remember one transaction, we were working on that one during the pandemic, and we received a very, very extensive RFI dealing with vertical relationship. I mean, it was more than what they needed, in my opinion, but yeah, they really took care or raised concerns about this vertical relationship. So I think those are the 2 new things that must be taken into account whenever you have a file in Mexico. And just to finalize, fines for extemporary filings, it's a mess. You can have a fine of 30, 40 US or $1,000 US. but we recently received one for 2.5 million, just for extemporary filing. What they say is that they want to send a message as a matter of public policy that filing needs to be done prior, because they notice that sometimes the client says, I don't have time to wait for the clearance, I need to close. That was a case in which we were working. It was a business decision. The client decided to go ahead with a merger and then make the filing. But 2.5 million, it's ridiculous, because in imposing fines, they need to take into account several issues like damage to the market, size of the market shares, intentionality, etc. They didn't take care about that and just imposed that fine. We filed the appeal, and it's on the court. And like 5 years ago, we received a similar amount of a fine. It was near 2 million, a little bit more than 2 million US. We appealed, and at the end, the final amount of the fine that was paid, it was only 10% of the original amount. So hopefully we will be successful in this one. So I think that's it for mergers in Mexico.
Thank you very much, Amilcar. Beatriz, what about in Chile? What is the current status regarding mergers?
First of all, thank you very much for the invitation. It's my first time here in IBRAC and in Sao Paulo, and it's been a great experience. Regarding mergers in Chile, since 2017, we have a pre-closing mandatory regime before the antitrust authority, and when certain thresholds are met, of course, and while we have a very strict timetable for the authority, the time haven't been all the fast that we expected. So that's to say it, and to establish certain expectations for the clients. It's very important. And when the mergers are prohibited, are blocked, we have like only one special appeal resource before the antitrust court. And we have a recent case where, although the authority blocked the merger, the antitrust court blocked the merger as well. The parties went for a disciplinary action before the Supreme Court. And they succeed, actually, and the Supreme Court reversed the decision. So what I can say about mergers is that it's still a developing issue. There are always procedural issues that are being discussed. And although we thought the law was very clear, we can expect different things, especially because of the Supreme Court criteria.
Interesting. Well, let me change now to the US with Chris. We heard yesterday in panels about the V+ guidelines, which is the non-horizontal guidelines in Brazil that were under public consultation, and that CADE is now working on those guidelines, on the comments that they received on those guidelines while they were under public consultation. I know that in the US, in 2021, the FTC withdrew guidelines that were brand new. Michael shared with us yesterday that in the similar date in which we had the Brazilian guidelines at public consultation, they were also for public consultation in the US, and that the authority is now working on such comments now as well. So I would like to hear from you, what do you think are the potential impacts of those new merger guidelines in the US, and any other interesting topics that you have to share as well?
Sure, thank you so much, Ana, and bom dia a todas e a todos. I think we've been hearing about how long some of us have been here, you know, at IBRAC. The first time I came was 2012, when just immediately after the new Brazilian law went into effect. And of course, one of the hot topics at that point was, of course, all the changes to the merger provisions, the introduction of the pre-merger notification system, and all of that. And we really see how much has happened, you know, like in Brazil over the last decade, 11 years or so in that regard. And of course, how it relates to other jurisdictions' merger control regimes, including in the United States. Ana, you asked about, and thank you again for the invitation to be here, it's truly a pleasure. You asked about the vertical guidelines, the V+ guidelines that CADE put out or released just a few months ago. And I think it's really been an interesting experience and exercise, both for the Brazilian Competition Authority and the community, but also internationally. Last year, even as CADE was working on its draft, I had the opportunity to comment and discuss some of the US and international perspectives on vertical issues. And then I actually also had the opportunity to participate in the ABA commenting group that also submitted comments, really, congratulating CADE on this effort and just asking for a few clarifications perhaps on some of the definitions and some of the issues in that regard. But how it also relates to the US, and as you really see, vertical merger enforcement really has been stepped up in a number of jurisdictions worldwide. And the US and the US agencies, the Federal Trade Commission and the Department of Justice, have also really been focusing heavily for the last few years on vertical mergers and issues in mergers that might be related to some vertical issues. And what you really see is, you mentioned that in 2020, there was a vertical merger guidelines that the agencies in the US put out, from which the FTC pulled back and then it rescinded in 2021. The Department of Justice did not officially rescind, like the 2020 vertical merger guidelines, but what you see is a few months ago, and many of you, all of us, have been receiving all the updates and merger law firm alerts and all of that about what's been happening on the policy front, in particular with the release of the draft merger guidelines in the United States. So those were released in July for public comment. The agencies received actually over 3,000 public comments on the draft proposal, and needless to say, it's been a longer ongoing process because even last year, before the draft merger guidelines, the agencies already ran a detailed request for merger enforcement information, kind of like RFI process. So what you really see based on the initial commentary, and I'm not going to go into a lot of details on the guidelines, but what you really see is kind of like the change of tone and the rhetoric that the agency leadership for the last couple of years has already been using when it comes to merger enforcement, and truly an increased scrutiny in a number of aspects. One thing that I would highlight that a number of commentators have also raised is that this is the first time since 1968 when, since then the US agencies have put out regularly about every 10, 15 years, new merger guidelines. This is the first time that this draft merger guidelines actually include cases, and many people actually, said that they're very similar to legal briefs instead of having, like a guideline type of setup and framework to guide when it comes to how, the agencies review mergers, how they analyze mergers and transactions and such. The key concern here that has been highlighted in hundreds of comments is that most of the like the citations, most of the cases that the agencies use are from the 1960s and 70s. And it seems that as if for the last 40 years or so, merger enforcement, and in particular merger decisions by courts, wouldn't be taken into account now by the FTC and DOJ. A couple of things that I wanted to add is, the guidelines have a totally new structure, having 13 independent or set of guidelines focusing on different issues. And you really see that on the one hand, they significantly lower the presumptiveness threshold for illegality for mergers. They also introduce, as part of the broader scrutiny on vertical mergers, totally new foreclosure share, kind of like presumption regarding vertical mergers. But also focusing on the broader non-horizontal aspect of mergers, they also focus heavily on conglomerate effects, and in particular, they bring back one particular theory, the so-called entrenchment theory, that from the 1960s and 70s, the agencies pretty much abandoned back then, and then now you see it as part of kind of like the broader scrutiny of non-horizontal mergers and the aspect in that regard. And in general, what you really see from the guidelines is that they really put the burden more on the merging parties to prove that a merger is not anti-competitive versus what you actually have to do in the courts for the agencies, which is prove that a merger would be anti-competitive and would prove, like competitive harms in that regard. So you really see this significant shift and changes both in the rhetoric, in the policy documents, and also in the enforcement actions of the agencies. When it comes to enforcement actions, the agencies went to court over the last couple of years 7 times. They took, 7 merger challenges to court. They won actually only one of those matters, the DOJ case and the publishing houses, Penguin Random House and Simon Schuster merger, the only one that the agencies won. So it's interesting to see how all of this will play out in the longer term. But importantly, I just wanted to add that you really have to see that the courts have really, in the United States, adopted the previous guidelines and used them as previous, guidance in their decisions. There is a big concern now that, based on the significant departure from economic studies, from economic literature, from economic thinking, and going back to old case law, that the big question will be whether courts will take these guidelines on board and how successful they might be in that case. So, be on the lookout for the final version. Those are to be expected in the coming months. And just one last point that I wanted to add is, it's also interesting and very important to see how, when it comes to pre-merger notification rules and form, you might have also seen that in June the agencies the FTC put out a proposed rulemaking to change many of the rules regarding the HSR, the Hart-Scott-Rodino pre-merger notification form. And it really provides a much deeper and much broader set of requirements for merging parties that they should provide as part of their pre-merger notification. And it applies to all HSR, basically all applicable transactions. The agency's guess is that, or their estimate is that instead of 37 hours, which is their current estimate for how many hours it would take right now, on average, to put together an HSR filing, the agencies themselves say, and the FTC document says, that it will be increased at least 4 to 5 times to approximately 155 hours on average. But with complex transactions, it actually can increase 7-fold to approximately 259 hours. And that, again, is on average. And when you speak with potential merging parties, companies, many people generally, and you see it in the comments as well, have raised concern that this is actually much higher in practice. So how this will play out and how we'll see the impact of that, again, this will be a document that is to be finalized in the coming months. I think we have to be on the close to guide, but they will definitely significantly impact merger activity.
Thank you. Yeah, we are all curious about those guidelines in US and Brazil. Felipe, talk or pass? Okay. So let's move to cartels and information exchange and other collusive behavior. In Brazil, there are now at least 3 ongoing investigations on the exchange of competitively sensitive information among competitors. I'll highlight one of them, which is the exchange of information among HRs of medical technology companies. And in this case, such companies allegedly exchanged information on workers' compensations and benefits. It is still unclear in Brazil whether such cases will be reviewed under the per se approach or under the rule of reason approach. That said, there are recent guidelines on cartel fines that treat the exchange of information, even sporadic exchange, and even the unilateral disclosure of information as a subset of cartel, which may give a hint on how CADE may want to look at that. And I was just wondering, so Felipe, we are eager to hear you. In Colombia, do you have anything similar, so similar investigations?
Thank you, Ana. I want to first start by thanking IBRAC for the invitation. It is my first IBRAC event, certainly not the last. I am pretty impressed by what you have achieved, and I want to thank especially the leadership of IBRAC for having me today. I want to first start by saying that Colombia appointed a new director of competition in March or so. And what we have started to see from that point on is a much higher enforcement, not only in cartels, but also in unilateral conduct and in gun jumping. And we're likely to see much more cases in the coming months, because as private practitioners, what we are observing is that clients are starting to receive RFIs, which are not those RFIs where you think they do not know where they're going, but pretty smart RFIs. So I think that in the following months, the authority would be much active in comparison with what happened between 2018 to 2022. In terms of cartels, apart from the regular price fixing, market allocation, bid rigging that we see in Colombia and in other countries, there's a particular focus of the authority in labor markets. So in the past year and in past few months, what you see is a focus on exchanges of information and agreements in terms of salaries, contracts, contract terms, and even an authority considering that the sole exchange of information, if it's quite specific and risky, may be in and of itself an antitrust infringement in Colombia. And this is reflected by two recent cases. The first, both in the football soccer markets. The first one is a case that the authority is prosecuting, in which it found initially that the Colombian Football Association, the DIMAYOR, which is the association that organizes the tournaments, and several teams, soccer teams, in the Women's Soccer League were exchanging information on salaries, were apparently imposing caps to the salaries of women athletes, and were also coordinating other terms of the labor contracts that each team has with the women athletes. It is very, since there's a couple of smoking guns there, I think it is likely that at least some teams will end up in having to give very serious explanations. That's one case. The other case is also in the soccer leagues, but in the men soccer tournament, where the authority found that apparently the teams were establishing blacklists for those players who could not be hired by other teams. And those blacklists were composed by those players who unilaterally terminated their contracts, stayed as free agents, and then were hired by other teams. But of course, in that scenario, the previous employer lost its ability to sort of earn the money of its investment in the athlete. So they made these blacklists. The authority found out. It initially negotiated remedies and an early termination, but it then revoked that negotiation, and the cases are still going on. But that's a very high focus right now of the authority.
It's very, very interesting. Beatriz, what about in Chile?
Well, in Chile, it's safe to say that cartels have been the main focus of the authority in the past 10, 15 years, I would say. And since 2017, hardcore cartels are anti-competitive per se, and collusive agreements can be criminally prosecuted. And executives involved face up to 10 years in prison, with at least one minimum year of effective prison. So we haven't had any cases yet, but we now have a case in the transport of valuables where the authority had already said that it has reserved the criminal actions that can be prosecuted afterwards the trial before the antitrust court. It's also very interesting what is happening with leniency in Chile, because a few years ago we had our first leniency application from a natural person, a standalone natural person, without any enterprise behind. And what it's been discussed is whether that's a whistleblower actually happening there, which is not recognized in Chile, or it's a leniency application straightforward. And we don't know, that's being discussed. In the same case I mentioned, the transport of valuable, and I think the result is going to be very interesting because will affect the case which started with this leniency. And relating with the sensitive commercial information exchanges, as in Colombia, in Chile, it's a very important topic, and I think information exchanges have been at the core of all the cartels cases in Chile. And the authority use all these exchanges as the main part of the evidence to prosecute the cases. And which is, what is very interesting on this regard is that the courts has stated that when exchanges are happening, it's hard to find an alternative explanation, and there's no other conclusion that it's because there is an agreement between the parties. That was the case in a laboratory case where the parties exchange the spreadsheets with the target prices, so it was very straightforward, and the spreadsheets were co-edited by different executives of different companies, and I think that was a discussion that was really deep because always the companies have an explanation, but at the end, the authority and the courts are very clear on that they are not going to tolerate this kind of behavior. And what's also interesting in cartels is that we have two recent cases where the authority settle out-of-court agreements with, I would say, small entities involved in information exchanges, and both settlements out-of-court agreements were approved afterwards by the antitrust court. And what's interesting about that is that we can see that both the authority and the antitrust court are willing to accept agreements and settlements and I would say commitments when small entities are involved in horizontal conducts that are, of course, the main focus of the authority. And we can expect that be considered by clients in the future, and of course by all the lawyers when analyzing a conduct. And just to finish regarding cartels, I think it's also important to say that not only effects are not necessary, only the availability of the effects, but the materialization of the agreement, it's also not necessary to sanction the conduct. This was said by the antitrust court on a decision upheld by the Supreme Court, and this was a case where the executive that was supposed to implement the agreement wasn't in the country when the bidding process was being carried out, so the agreement didn't occur, but the agreement exists prior of the bidding. So once that evidence was provided to the antitrust court, there was no discussion, and the antitrust court sanctioned the conduct as well. So not the effects are not necessary, but the materialization is not necessary either, and that's very important when advising clients and explaining why some conducts can be so risky before the eyes of the authorities and the courts.
Very, very interesting. In particular, the topic on the leniency with an individual. I've never heard of something like that, at least here in Latin America, I think. On leniency agreements, so since the peak of car wash investigations, we saw a decrease in leniency agreements in Brazil, but we have been hearing from CADE that there is not a negligible number of leniency agreements under negotiation, so those negotiations are confidential, so let's see how it goes. But I would like to hear from Miguel and Amilcar. So what about in your countries? How are leniency agreements going and cartel investigations?
Okay, let me start, Amilcar. So let me mention two very relevant cases regarding leniency. The first one is our well-known Cuadernos case, the notebook case, which is a similar case than the car wash investigation. This is a driver from a former official of the Peronist government that drove some big shot enforcers while they were collecting campaign support baggages with campaign support money. And the driver was taking notes of where they were going and how much, everything he listened over these people speaking with their cellular phones. He was taking notes because he was scared. So these notes, there were 7 notebooks. They were given to a journalist. They were published, I think, 2017 or 2018. And it ended up in a big criminal investigation against more than 50 companies. Practically all the presidents or CEO of these companies were detained. They were detained on a Friday afternoon, and they stay in jail Saturday and Sunday, full of drug addicts and the people you regularly see in jail. So on Monday, all these people decided to enter the witness protection program in Argentina, and they basically accepted that there was collusion, that they agreed the bidding terms and conditions on here we're talking about the specific market of roads and highways. So in the criminal investigation, they accepted the existence of a cartel. The Antitrust Commission initiated an investigation, asked the criminal judge to provide copies of all testimonies, and now the first issue came, and was that none of the investigated parties wanted to require leniency. We've worked with our team very hard in them. We represented many of them. They didn't want to inquire about leniency. They didn't want to receive leniency protection. Our comment was basically, you accepted in front of a criminal judge that you were part of a cartel and you're not requiring leniency. So they didn't want to require leniency, and of course there's always an explanation behind that. Cristina Kirchner was the main person under investigation in this case. Cristina and her husband, her died husband. Alberto Fernandez took office in 2019, and this case has finally been closed in August this year. Without continuing with the investigation, because per the Antitrust Commission analysis, there's not enough evidence that there was an antitrust, anti-competitive conduct behind this case. So this is sad, to be honest, but it's a proof that for a leniency program to be effective, you really need an authority that is really creating fear that they will sanction the companies. If you don't have that fear, nobody will require leniency. And the other case, which is a case I like a lot, it's a case that took place in Bariloche. I think all of you know where Bariloche is. You've been there for skiing reasons. But Bariloche is also a hub of students, of graduating students that during their last year in high school, they go there for a week just to party and have fun. So when you get into Bariloche, the first thing you see before watching the mountains and the snow is that the city is full of disco and nightclubs. Well, there was an agreement between these discos and nightclubs. They basically agree on prices and they allocated markets. And they even executed an agreement that was prepared by lawyers from Bariloche. So they were very serious and very formal. And the issue here is that one of the members of the cartel breached the agreement. So the lawyer in Bariloche had the great idea of going to Antitrust Commission to enforce the agreement, because he said, you're breaching the agreement, you need to comply with the terms of the agreement. And the Antitrust Commission said, this is amazing. They just come here to ask us to fulfill their agreement. So what the Antitrust Commission said basically was, come here, I will explain you how the leniency program works. I will give you some of the benefits of the leniency procedure, and you have to tell me everything about this cartel. And that's exactly what happened. They gave the commission all the evidence. There was a big sanction against all the parties, and this unbridged party received a 20% reduction on the fine. So this is basically how leniency is working in Argentina.
Thank you. In Mexico, well, we have a new head of the investigative authority. The investigative authority is the one in charge of investigating cartels, abuse of dominance, gun jumping, everything. He's doing a very good job. He has been in office for maybe a year and a half right now, and I think he's doing a very good job. He's not a lawyer, he's an economist. And in addition to him, there's also a new director for cartel cases. As a result of these new appointments, a lot of investigations have been recently launched. But going to the specific of leniency applications, in Mexico they are still popular. I mean, many years ago, as in many other jurisdictions, the leniency applications were a result of international cartels. But right now, to the best of my knowledge, most of the leniency applications are related to local cartels. They have raised the bar. Many years ago, it was there's a urban legend. I don't know if that's true or not. That one of the first applications for leniency, the attorney arrived with a ticket of a Starbucks and said that the client took a coffee with some competitors, and the proof was the ticket of the Starbucks. But well, that was many years ago. Right now, they have really raised the bar. I think too high. And let me give you an example. Right now, we're working in one case. It started in the pandemic. Leniency in Mexico is kind of strange because you apply for leniency, you need to provide evidence of the illegal conduct. This is the leniency application period, which is absolutely confidential. Once they believe, the COFECE believes that they have a case, they will open the investigation. But what is kind of strange is that during this investigation period, they will investigate the applicants as if they were not applicants. For example, they will downrate the company. Of course, they will call you. It's a kind of fake downrate because they will call you. They will ask you which date the company could be downrated, and you have the executives ready to receive them. So during the pandemic, of course, downrates were not available. They asked my client to copy the main devices and give a copy to COFECE of that devices so they may start gathering evidence. So we did that, and they keep the devices 3 or 4 weeks, I don't know, to conduct their own research. Once the pandemic ended, they told me that they want to conduct this downrate. So they did the downrate, and they found 2 or 3 different emails that we didn't, in our internal investigation, the client didn't found. COFECE didn't found also that evidence during the downrate. Sorry, when they have the copy of the devices. And they found those emails until they conducted the downrate. And they told us that we were not cooperating, that it was very disappointing, that we didn't provide that evidence since the beginning. And my reaction was, well, you had the copy of the devices 3 or 4 weeks. You are the experts in conducting these forensic reviews, and you also didn't find it until the downrate. So finally, I mean, they accepted, they believe we are still cooperating. But again, the bar is right now very high. Another issue that they raised is that they want to have very clear evidence of direct contact among competitors. In a case we are working, another case we are working right now, what we found was communication among the employees of the company saying that someone else was breaching the agreement. And COFECE keep asking for emails not among themselves, but with a competitor. And we told them, we don't have them. I know, they know that this is kind of illegal. Maybe that's why they don't have that kind of information with competitors. But I mean, we spent like a couple of months in that discussion. And I told them, okay, if you believe you don't have a case, just drop it. But I cannot give you evidence that I don't have. So the bar has been raised. And just to conclude, as in Colombia and Chile, human resources is also an issue right now. There's a famous case also in the female soccer league. It was penal sanctioned. It was clear that they were agreeing on the salaries, which according to the law, it's clear that that will be an illegal conduct. What is not that clear, actually in my view, it's not illegal, is the no poach itself, an agreement not to hire employees from competitors. If you take a look to our, of course we're a civil law system, so everything needs to be clearly stated in the law. And if you take a look to the antitrust statute, an agreement not to hire among competitors is not an illegal conduct. Some people in COFECE believe it's illegal, some others believe not, so we'll see. But exchange of information in human resources is an issue right now also.
Thank you, Amilcar. So Chris, do you have something or?
I think when it comes to interesting matters, it's difficult to compete with Miguel's Bariloche nightclubs case. So in the interest of time, I would just...
I was wondering what happened to the lawyer who advised the contract.
So let's just perhaps move on to the next topic.
So you win. So let's move to abuse of dominance. We heard from Carolina Elena, the general coordinator from CADE yesterday, that CADE is working on guidelines on abuse of dominance. We had at least 3 cases in Brazil in relation to exclusivity agreements with interim measures that ended up with settlement agreements with the companies. And I would like to hear from you. So let's start with Miguel. What is the current status in Argentina regarding abuse of dominance?
Okay, perfect. I'll try to be brief because I know we don't have that much time. And I'll talk about only one case in which Beatriz is also involved on the other side. So it's interesting to talk about this case. This is the beer case. Yesterday there was a panel even by Daniel Andreoli about this topic. These type of cases are very difficult to demonstrate. And in my experience, once the authority decides that there was an anti-competitive conduct and decides to impose a sanction and a remedy, then the remedies are very difficult to comply. In my case, I represented Heineken against IBA, Quilmes in Argentina. Remedies were imposed, and the remedies end up being very general because the remedies are something like you should not be executing agreements with exclusivities with the point of sales. You should not offer marketing material that will grant you some sort of exclusivity. You should report to all your distributors about the decision of the Antitrust Commission. So imagine commercial people receiving a decision by the Antitrust Commission. It's like nothing. So in my personal experience, these cases are great cases because they are very difficult to prove. They are very interesting. But once you have the decision, how do you really create remedies that will protect the small producers, let's say, no? And there is where I see a lot of issues. In our case, let me be honest, we control how Quilmes try to comply with the remedies. We discovered that they were not basically complying with the remedies. So we filed a complaint with the Antitrust Commission saying, look, they are not complying with the remedies, you should investigate it. So the Antitrust Commission sent a note to ABI, and ABI reported to the Commission that they sent the letters to the distributors 6 months after the decision was issued. And I said, great, so they delayed for 6 months to send the letters. So they should sanction them because of that, because they are not complying with the remedies. And that's exactly what the Antitrust Commission did. They sanctioned for the second time the company because they were late in complying the remedies. And now we are complaining again that the remedies are not being complied. I know Beatriz is on the other side because Beatriz in Chile is basically complaining to my client who is in the opposite situation in Chile. And I bet that you have the same problem that we have, which is basically we have a great decision here, but the enforcement of this decision is extremely difficult. And I will leave it in there.
Great. So, yeah, being mindful of the time, so maybe we can just go like Beatriz, Felipe, Chris, and so on, so that if you can comment on something on your countries briefly.
Sure. Well, as I said before, cartels was the main focus of the authority. And recently in May, a new head of the authority was appointed by the president. And I'm mentioning this now regarding abuse because he pointed out that he wants to enforce the anti-competitive the law with a focus on abusive behavior. And this is kind of new in Chile because we haven't had many cases. And following Miguel, I think that the main cases that we had in Chile regarding abuse were always settled with commitments, which make really hard to follow on the comply of the commitments. And what we are seeing now is that the authority is prosecuting the companies for the non-compliance of the commitments. And actually, it's really hard because I agree with Miguel that sometimes we as lawyers create these commitments that sounds really, really good, but to take these commitments and impose them to point of sales, to distributors, or actually to the commercial executives in the companies, it's really hard. So I think what we want to see now is with the ABA Heineken case that we have in Chile, where the authority actually filed a complaint against CCU, which related to Heineken for the non-compliance of the commitments. What we expect to see is how the authority and the antitrust court are going to solve this issue regarding how commitments are going to create concrete obligations and solutions for the parties that can be executed at a commercial level and not only on a legal analysis basis. What's also interesting is that we have had a few cases in unilateral behavior prosecuted by the authority, but on the private litigation area, we have much more cases. We have around 20 cases in the past 2 years where the private parties are more willing to go to the authority and are more willing to go to the antitrust court and file complaints against competitors or vendors or clients for anti-competitive behavior. And that's really interesting. We have had a few sanctions on this. We have a recent case in the bank industry where a bank was accused of using its dominant position in the context of a bidding process for collective mortgage insurance, where the bank decided to exclude the lowest bidding to benefit one of its related insurance companies. So that was sanctioned recently. And what's also interesting regarding the beers market is that not only the authority is prosecuting the non-compliance of the settlement, also ABA had already filed a complaint against not only for the non-compliance of the settlement, but also stating that the behavior is itself an abuse of dominant position, and that's going to be really interesting as well, because we are going to see what the antitrust court has to say about that.
Felipe?
Yeah, so in Colombia, the focus on unilateral conduct is really now on payments, both in credit cards and fintechs, and in energy markets. I'm going to comment on a case, a recent case against Visa and MasterCard that has been opened by the authority, because allegedly both franchises are blocking the operation of local collection agents, which is basically fintechs that facilitate the purchase of services and products for merchants from abroad. Basically, I mean, traditionally in Colombia, it was expensive to buy services or products from merchants who were not located in Colombia. So you had to have a credit card approved for an international transaction. You had to pay high fees. You had to go through the channel of Visa and MasterCard. And 5 years ago or so, new commerce appeared, basically local collection agents, which represent or have a mandate from the foreign merchant to do the transaction locally and then send the money to the merchant abroad. And that transaction, although is made also with Visa and MasterCard, it's much cheaper, and Visa and MasterCard gain much less money than when the transaction is done internationally. So what the authority found is that both Visa and MasterCard at the same time, although it is a unilateral conduct case, as it was opened, but both at the same time wanted to implement programs which mandated to all the agents in the local transaction to pay the same fees as if it were an international transaction, although it was a local transaction. And the authority said, look, this is basically eliminating the local collection agents and imposing costs which are not justifiable to the market. That's, I think, the case of the moment in Colombia. I'll leave it there.
Ana, let me make a comment here, because the case Felipe was describing is a very interesting trend in Latin America. We in Argentina are working exactly in the same case, representing the same client of Felipe, and this company, which in fact is an Uruguayan company, decided to file complaints in the different antitrust authorities all over Latin America. And what they are doing basically is sharing the decisions that they are receiving from the different authorities and filing with the other authorities. And this is a new trend that we are seeing with the globalization and the digital world, where you don't complain basically in one country, you go and complain in the whole region. No? Yeah. Chile has a... Exactly, Chile, Peru, Mexico, practically all of the countries of the regions are receiving this complaint.
Sure, thanks, Ana. So when it comes to unilateral conduct, that really is another area which really has been in the spotlight in the US for the last several months. You might have seen there are particularly two matters that really have really gained a lot of attention. One is the ongoing US v. Google trial that started in around mid-September, and it's going to finish, actually wrap up next week. So this case has been dubbed in Google's search as the monopolization case of the century, a couple of decades after the US Microsoft case, which obviously many of you are more than familiar with. When it comes to the Google search trial and the Google search case, one is to know that in August, right before the trial started, Judge Mehta, the US District Court judge, actually threw out a really big portion of the case based on the fact that he did not see, like evidence of anti-competitive harm in that particular matter. But if we think about just monopolization matters and just step back for a moment, we obviously see that the two key elements there, one is, market power, monopoly power in a particular relevant market, and on the other hand, some indicia of anti-competitive effects. There has been a lot of discussion and a lot of criticism that, like the US DOJ has been receiving on the case that it has built, or how strong it might be in this particular matter. On the one hand, on the relevant market front, it really focuses, the DOJ case really focuses on traditional search. So when it comes to, like traditional search engines, then it looks at, like Google versus, Safari, Mozilla, and other, Bing and other types of search engines, without trying to get a sense of how search is actually taking place, like these days, which includes, like additional devices, whether it's voice assistant, digital assistants, whether it's, like TikTok, other types of framework, other types of platforms that people seem to be using, or more specialized search platforms, whether it's in the restaurant or like food delivery part, whether it's in the travel search engine sector, whether it's in the shopping area, and more importantly, how the recent growth and the birth of many different AI type of like search engines actually significantly influences this market, whether it's ChatGPT, whether it's other products and platforms in this space. And when it comes to the other element, which is what kind of conduct are we really talking about? Really the case focuses on the agreements that Google has, with web browsers, with PCs, with different types of devices, for Google Search to be the default search engine on many of these platforms. And people have, as this trial started, called it, like a Microsoft 2.0. But I think when one thinks about what really the case is about, one can see it couldn't be farther from that particular matter. On the one hand, it really, I think kind of like the only common denominator is that both of the monopolization matters against the technology company. But beyond that, I don't see any commonalities, which is interesting to see because when it comes to the Microsoft case, obviously bundling was a key concern there, and how Microsoft in that regard foreclosed competitors to actually get particular other types of like get to consumers, and how consumers had difficulties then trying to get on Netscape or other types of web search engines. Here, the core of the matter is really like Google negotiating with other like whether it's devices, whether it's web browsers or others, to be on their platform as like as the default engine. And it's really interesting to see that Judgment already has noted that these agreements do not seem on their face exclusive as well, because basically consumers can choose and then move on to other default browsers if they want. The other really important matter that came out late September in the unilateral conduct space is, you might have seen the FTC's monopolization lawsuit against Amazon, which again has gained a lot of attention. There's been a lot of discussion in the US about it. On the one hand, again, on the relevant market front, what the issues are there. And then on the other hand, what is the consumer harm, if any, that really doesn't seem to have been identified significantly by the FTC in this case, and what could be any potential remedy in this particular matter. So they really have kind of like revamped now the discussion on unilateral conduct issues in the US. And when it comes to some of the significant departures that we see, that perhaps I also mentioned on the merger enforcement front, you really see that on the single firm conduct as well. There's been a lot of discussion, are we then protecting competition and the competitive process, which has been the lodestar of competition enforcement, or are we actually focused on trying to help and aid particular competitors, which in a number of these complaints you see, whether it's references to logistics services, other retail companies, how they actually have to be taken into account as part of like these types of investigations. And importantly, whether the government now focuses on more based on the size of companies picking potentially winners and users. So be on the lookout for this, because obviously these cases will have very significant ramifications in the US and other jurisdictions as well for single firm conduct.
Amilcar, conscious of the time.
No, go ahead.
Yeah, great. So on our last topic on digital markets, all of you saw the DMA in Europe. We also had in Brazil the Brazilian DMA proposal, which is quite recent, and I would highlight in this proposal that it expands, so if approved, it would expand the competence of Anatel, the Brazilian telecom agency, in relation to gatekeepers and all those platforms. And it would also make all concentration acts related to gatekeepers in Brazil subject to mandatory filing with CADE. And I would like to first start with Christian, with his broad experience in technology and regulation. Do you have any comments on this proposal and on DMA in general?
Sure. Sure, thank you, Anna. Yeah, I know in the interest of time I would just make it very short, but it's interesting to see this proposal, especially, how closely it actually follows and mimics, many of the provisions that we see in the European DMA. I think if you see many of the provisions, they follow this very close, which is particularly interesting in the sense, the fact that, the DMA simply at this point is not operational, fully operational as of yet. There's currently the ongoing designation process. 6 companies have been designated in Europe under the DMA, but it will be fully operational only in the first or second quarter of 2024. So when it comes to international regulatory experiments or examples, it's interesting to see, they obviously all they might address different issues in different economies and different jurisdictions. So the basic question is there a particular economy-wide issue or harm that in another jurisdiction should or could be addressed with, for example, a DMA type of ex-ante proposal? What we really see is there is no, experience with the DMA. So far, the only ex-ante regulatory framework that over the last few years has been adopted and has been on the books, is Germany's so-called Section 19A from January 2021 as part of the 10th Amendment to the German competition law. And that has been an experience of about 2 years with that particular, ex-ante framework. The DMA, as I mentioned, is not fully operational yet. The US, for example, some of you might have heard about the so-called AICOA, American Innovation Online Choice Act proposal, that in the end, based on the fact how significant concerns both from an antitrust and other policy areas, data privacy, national security it caused, it actually pretty much died in Congress at the end of last year. You see other jurisdictions, Japan having a totally different approach through its Transparency Act with a co-regulatory approach to, like how to deal with potential issues in the market. So I think it's interesting to see that adopting, potentially, ex-ante regulatory frameworks that haven't even been in place and operation in other jurisdictions can obviously have significant impacts on full economies, innovation ecosystems, and of course on startups, whether it's in Brazil, the very emerging fintech sector, or whether other types of parts of the economy. And if you look at particularly the Brazilian proposal, just in August, a couple of months ago, I participated in this audiencia at the Congress when it comes to kind of like the Economic Development Commission that is looking at it very closely. And I understand that right now there's also public consultation going on this proposal. You really see that the thresholds are extremely low, approximately 7 million reais, which I think is about $14, $15 million in the US, which would mean that unlike the DMA in Europe, which captures 6 gatekeeper companies, the Brazilian proposal would likely capture, based on conservative estimates, approximately 140 or 150 companies in Brazil. But based on non-conservative estimates, it might even reach 400 to 500. So it's really interesting to see how that particular proposal, and we all know it's in the political process, so who knows if it will have legs in the end to stand on, or it will go through the political process, whether it will get adopted. But we really have to understand what the costs and benefits of those particular elements would be, what would be the impact, and I think an impact assessment in that regard would be very important to see. And last, how it would actually also impact Brazil's global export competitiveness. For many of those companies, whether it's self-preferencing, whether it's some other type of conduct they wouldn't be able to rely on, that obviously would have a very significant impact for the innovation, for the startup ecosystem, and of course for the broader economy as well.
Thank you very much. I knew you would have something very interesting to say about it. Felipe, what about you?
Very quickly, I'm very skeptical of DMA-like legislation in Colombia and other countries in Latin America. And it's a matter of priorities. I think there are other big priorities at least in the Colombian market, and consumers and the markets are not exhibiting, at least right now, a problem with the gatekeepers, at least from those who have been elected in Europe right now. I would focus more on telecoms, which we have a huge issue, the airline market, even retail in some cases, energy markets. And when we fix those priorities, maybe let's start discussing something if there is an issue, right? So doing a copy paste of the DMA to at least in the case of Colombia, and I guess it may be true in other countries in Latin America, may not be a wise thing to do. Also, one should ask whether the current antitrust laws do not provide the necessary tools to fight what the problem is or allegedly is. So I would start by prioritizing and then considering whether the antitrust laws do not fix the problem instead of starting to copy-paste a DMA-like legislation.
Interesting comments as well, thank you. Amilcar, Beatriz, do you have any comments on this subject?
Yeah, very fast in view of the time constraint. 4 or 5 years ago, the COFECE launched an investigation on digital markets, and after 7, 8 months, they dropped the case and they publicly mentioned that they didn't have the expertise to analyze such market. That was 4 or 5 years ago. Right now, there are 8 different investigations dealing with digital markets. Actually, one was the investigative period ended, and 2 days ago, on Wednesday, they served one company, it's not public, the name of the company, with a notice of probable responsibility in the digital market, digital advertising, I'm sorry, in that market. Also, there is a kind of, COFECE is in charge of reviewing every market except for telecom market. The telecom market is in charge of the Federal Institute of Telecommunications. Sometimes it's very clear that an investigation is on the court of the Telecom Institute. Sometimes it's very clear that it's on COFECE's court. But sometimes it's not that clear, and actually they have litigated among themselves who is the one that should be in charge of an investigation. Also, during the pandemic, the Telecom Institute launched a very aggressive investigation dealing with several conducts. It was kind of crazy. COFECE filed a complaint before the tribunal specialized on competition matters, saying that COFECE was the one with jurisdiction over that case. The tribunal ruled in favor of COFECE, and COFECE decided to close the case because they believe it was crazy, that kind of investigation. But I mean, just to conclude, it's a hot topic right now in Mexico. 8 investigations recently opened dealing with digital markets.
Thank you. And Miguel, would you like to wrap up?
No, I wouldn't say that the DMA is a concern for the Commission in Argentina. They recently formed a group to start studying the matter, but there's nothing to report on this.
Okay, so do you have any questions to our panelists? I think we have to end now, so please join me in a round of applause to our... Sorry, I couldn't see you.
Thank you. First of all, thank you, Miguel, for the panel. It was great. Chris. Thank you. It's very good to see a lot of friends there. My question is to Felipe. Felipe, you mentioned an investigation on unilateral conduct in the energy sector. Can you provide further details about this investigation? Or these investigations? Sure. I don't know if it's one
of them. What the Competition Authority right now is paying attention to is the fact that energy prices are going up. And since energy prices are going up because of climate problems, they are inquiring on gas companies who sell the gas to the generators on how are they doing arbitration of those sales. So it's not in and of itself against the generators, but on energy markets in the upstream. So that's what the authority is inquiring. And it's not, something I didn't comment on the Visa and MasterCard, which is important, is that it is not an abuse of dominance case, because in Colombia we have this provision who allows the authority to investigate unilateral conduct without the agent being necessarily dominant. Although it has certain power in the market, it doesn't have to be dominant. So what the authority is doing is, under that clause, investigating certain companies, at least preliminarily, in the analysis, to see whether what they're doing is breaking the gas contracts they have for a lower price to sell in the market right now the gas with a higher price, which is going to impact the energy markets in the downstream. That's what the cases are about.
Felipe, what is the threshold for a dominant position in Colombia?
There's not a threshold.
No.
Usually the authority starts concerning when you have 40% or more, but there's no threshold. It depends on the case and on the market.
Any other questions? Okay, so we are really on time. And I would like to join me in a round of applause to our speakers. Thank you all.